family business just got closed. Getting a little emotional here because it was a very, very tough thing for me.
The agency had looked at his product multiple times and blessed it, and they didn't turn that evidence over to him when they were coming after him for a severe civil penalty.
And the agency has no duty to disclose, helpful material to you. How are you supposed to, win these cases?
Well, maybe that's the point. Good afternoon and welcome to today's Lunch and Law episode. The New Civil Liberties Alliance is glad to have all of you with us for our program on DOT backs down after NCLA sues over unfair in-house tribunals. And we have three fantastic guests to discuss that with us today. Litigation counsel Sheng Li. We have Jerry Cox with Potomac Strategy Associates, and our client Neil Werthmann, owner and president of Polyweave Packaging Inc. Sheng, would you like to say more about our two guests and why we have them here today to talk about this?
So Neil is as Mark just mentioned, the head of Polyweave. It's a small company in Madisonville, Kentucky that, as Neil would explain to you, makes packaging used for transportation. Does not make explosives, but just packaging used for transportation of explosives. And Jerry is a guy who's been, tangling with the administrative state for many decades now, on one form or another, especially the Department of Transportation. He's been of great help to NCLA in litigating with us and helping us find clients such as Neil.
And has the bruises to show for it, Jerry?
I'll just say it's more decades than I want to count.
Very good. Why don't you get us started, Sheng? What happened here? How did NCLA get involved? And give us a little bit of the backstory here of sort of maybe even before Polyweave got involved. What was happening at the Department of Transportation that this administration undid?
Right. So this all started back in, back in 2019 when under the previous administration, the general counsel at the Department of Transportation recognized a lot of due process violations occurring during enforcement actions. So what he did, Bradbury, wrote a memo that enacted a policy of due process protections for companies that are being prosecuted by the agency. And what happened to Polyweave was that in the middle of being prosecuted by the agency, it had these Bradbury protections. But in 2021, when a new administration came into power, it yanked those protections out from Polyweave, leaving them with very little. At that point, NCLA got involved, represented Polyweave to challenge the rescission of those regulations. A few months after that, the agency actually found...
Can I just interject and say, we had the crazy idea that maybe the government shouldn't be able to change the rules in the middle of the game when it's prosecuting you.
Yes.
It's just a thought, but...
So I wanted, actually, in the middle of that litigation, one of the Bradbury protections was that the agency has to disclose exculpatory material to the target of enforcement actions, which is a rule in criminal courts. All criminal defendants get it, but agencies...
It's called the Brady Rule,
the Brady Rule,
Brady
exactly.
v. Maryland case at the Supreme Court.
Some agencies do it. I know the CFTC does it. The SEC has a variant of it, but the DOT did not until Bradbury implemented it, but then it took it away. And it turned out there were something like 600 pages worth of exculpatory material that the agency just never gave Polyweave, including inspections of Polyweave's customers that were using Polyweave's products and finding those customers didn't violate any law when using Polyweave products. So if Polyweave products were somehow unlawful, you would think their customers using them may have been, targeted, but no violation there. But in any event, a few months after that NCLA's first lawsuit, the agency actually issued a final agency decision against Polyweave and hit them with a civil penalty. The first lawsuit was filed while the administrative proceeding was still ongoing, which at that point was supposedly a big no-no, but NCLA in a different case allows that to happen now in the Cochran case. But in the second case we filed for Polyweave after that civil penalty was issued, challenging the civil penalty. After our briefing in that second case before the Sixth Circuit Court of Appeals, the agency came back to us
And let me interrupt you there because there's a very fun thing that happens there. But before we get to that,
Sure.
I thought maybe we could go all the way back to the beginning with Neil and just what was the thing that the agency thought you guys had done wrong at Polyweave?
Yeah, it all started, one of their agents went to one of our customers, and the customer was actually filling our product. It looks like a tube sandbag is what it looks like, and it's used for commercial explosives. It actually is like the wrapper of a firecracker, provides the waterproofing for the explosives. So if you drop it down a 200-foot borehole, you hit the water table at 100 feet, it waterproofs the explosives so they can still do their job in the mining industry. So they went to one of our customers, and while they were there, the customer was filling our packaging, and they noticed some of the print was not legible on the package. So that's how it all started. And that was first week of April 2015. So I sit here 8 years, 2 months, and several days later. Not that I've been counting the days. It's not been a stressful event at all for me, trust me. So yeah, been a long road, but that's how it started. My customer called me and said, hey, this guy was here. He went livid over the bags. He said you were his next target. So just wanted to give you a heads up. And that's how it started.
Good customer to give you a heads up.
That's
always good.
So.
And I understand that there was an issue. They alleged that there was an issue in terms of how frequently you were testing the packaging.
Yeah, what happened going all the way back to 1992 is when the regs came out for the certification of R-type packaging. And my father, it's a family business at the time, said, you know what? We're going to get self-certified and do what none of our competitors do, and that way our customers would like to use us instead of somebody else. So that sounded like a great idea, but years later in the world of liability we live in now, maybe not the best idea. So we got self-certified, and then we were able to go out and I would actually perform the testing on the packaging at all our customers around the US. And I was doing that since '92 for approximately 23 years when this agent came in and pretty much said everything we were doing was wrong. And so I was like, so 23 years, the big gray area was they have I call it either it's a composite or a combination package. And our bag is actually a tube sandbag, outer woven bag with a polyethylene inner liner. So we put this liner inside the outer woven bag, and that's what gives the bag strength and waterproofness for the finished product. So we believed and were educated by an employee of PHMSA, actually all the way back in 1991 and 92.
And that's the Pipeline Hazardous Materials Safety Administration, PHMSA. I know we have lots of acronyms in DC, but that's the one that regulates this particular packaging.
Right, so my father worked closely with them in 91 and 92 and came up with the test report that we came up. They kind of co-authored it. So we really felt good about it and thought, hey, we're doing really well here, we're good to go. But then this agent comes in 23 years later and says, everything's wrong. So I was like, okay, so he made advice and recommendations and everything. And the one thing that was very unnerving, among other things for me, was that we believe we have a combination package. We're taking two bags that we sell individually to different customers as is, but then we also combine the two bags to make one product for another customer. So we thought it was a combination package. One bag, combine the two bags together to make the finished bag. So the gray area is that the combination packaging is done, testing is done every 24 months. The single or composite package is every 12 months. So as the nice agent informed me, every bag that I printed, labeled, manufactured, and sold for that 12 months was a finable offense, up to the max of $475,000 per incident.
And I just wanted for the audience, just give you the definition of a combination and a composite package.
This is good.
And you guys can figure out which is which based on Neil's description. So a combination package, which is what he thought he was doing every 2 years, is one or more inner packagings secured in a non-bulk outer packaging. Sounds like what he was doing, kind of, right?
Sure.
Now listen to composite packaging, an outer packaging and an inner receptacle, so constructed that the inner receptacle and the outer packaging form an integrated packaging. How are you supposed to figure out which is which?
And why does it matter whether it's 1 year or 2 years? Why would you have a different rule for those two things? That's the other thing. Let's just call it 18 months.
Yeah, right.
Yeah, so it was quite an ordeal. But then,
but you had asked them which one it is, and they had given you the guidance that every 2 years was
back
fine.
in 1992, they said it was a combination package. So that's what we ran with. 23 years of agents in the field, of course, inspecting these explosive facilities, many times would look at our test report and would compliment it, saying, hey, it's a great report, everything looks good, you're good to go. And then this particular agent found a lot of holes in it, so he thought, and turned my world upside down for 8 years.
And then Jerry, I thought, if you were going to say something else, go ahead and jump in. But what I was going to ask you is if you could put a little bit more color on some of these problems that there were at the Department of Transportation that Steve Bradbury and some of the folks were worried about.
Those regulations are now more than 1,200 pages long. When I was working on Senate staff and we did oversight on the Hazardous Materials Transportation Act when it was 6 years old, the regs were about like that, and now it's in 2 volumes of the CFR. And you have one kind of regulation that's unintelligible. You have another kind of regulation, which is the kind that just doesn't exist. And a lot of these inspectors show up and have their own interpretation. They don't even talk to the agency lawyers. They haven't read the stuff either, half the time. And they decide on their own that you violated a regulation that doesn't even exist. And I've handled about 40 cases, mostly for very, very large corporations that can afford it. And so now people are saying to me, why are you doing anything pro bono? I mean, what is that all about? And I said, because the agencies invariably, if you fight them, if you've got somebody, you're paying somebody who knows how to fight them, they give up.
Yeah.
So I've had something like 40 cases that cost the clients a lot of money, and then the agency says, well, never mind, or you just never hear anything else about it again. They're not even obligated. It's one of the Bradbury reforms was if you've decided you're not going to pursue it, then
you have to tell them.
Say so.
Yeah, you have to actually end the case. You can't just leave it open indefinitely.
So I was frustrated by that and but I knew that there were statutory and constitutional issues that really needed to be addressed here. I knew the agency really wouldn't want to confront those issues, but the only way I could do that would be to get to an Article III judge. And every single time, they have kept that from happening. So when the opportunity came up, for somebody who was sort of on the verge of having a case that was ripe for going to the Court of Appeals, Neil will tell you, I called him up just like dancing around, darn near dropped the cell phone. I'm so happy this agency has handed this to us on a silver platter. And when that happened, Sheng wrote a spectacular brief in the Sixth Circuit, so spectacular that the Justice Department looked at it and said, oh my God, we can't lose.
We can't win this.
We can lose on this. And so they came up with a way to dodge it. And that's where the case stands at this point, is that those issues haven't been resolved yet.
Yeah.
But the agency a few weeks ago handed us yet another case where we can go right straight to those issues. We don't have to worry about them. Well, I suppose they could still dodge it.
Maybe we can come back to that at the end. But Sheng, I think that's a good segue back to what you were getting ready to say before, which is sort of where this stands, or how the agency squirmed out of a decision here.
We raised a number of arguments to the Sixth Circuit, including that the guy who actually issued the final civil penalty against Neil and Neil's company didn't have proper authority because he wasn't accountable to the president. He's actually a civil servant. He's not a political appointee. You can't fire him. So he doesn't have what's our argument? He doesn't have the authority to do this because the president doesn't have enough control over what he does. Turns out that was correct, but that maybe hit the nail a little too much on the head, because the agency came back and said, actually, we've dug around, and he was actually never even appointed to exercise this authority.
It's worse than you thought.
It's worse than you thought. He was not only is he protected from removal, he was never properly appointed to issue civil penalties in the first place.
Mind you, the Supreme Court handed down a decision that NCLA was involved in. It was our very first case as an amicus, called SEC v. Lucia, and the result of that case was that the Supreme Court handed down a ruling about what you had to have for a proper appointment of these administrative law judges. They needed to be appointed by the president or by the head of a department, and that's what hadn't happened here. But there was a memo that went out from the Department of Justice after the decision.
In 2018, the Supreme Court said exactly that you have to appoint these adjudicators in a certain way. It has to be the department head or the president, and then the Justice Department sent out to every agency, please do so. Take all your adjudicators and now appoint them or reappoint them or properly in some way. It was a very widely circulated memo. Everyone knew what was going on. We thought every agency did this. DOT apparently did this to some of their adjudicators, but not this guy. And so it turned out, and he's been actually issuing cases for just making final decisions since 2017. Now, he didn't know better in 2017, but he knew better after 2018, and he kept on at it. And there's a couple dozen cases that has this person's name on it.
There's a backlog.
Yeah, and the agency has said he does not have authority to issue any decisions from at least 2018 to when they admitted this problem to us in 2022. That's a 4-year period in which dozens and dozens of companies have been fined by someone who just absolutely lacked any constitutional authority to issue fines.
But surely the agency told these people that the person who issued the fine didn't have the authority to issue the fine.
Not only that, but 2 days after the agency told us and told the court that he didn't have that authority, the same guy issued a $100,000 fine against a different company. The same guy. So that's another case we're involved in, but it just goes to show you this is a kind of Kafkaesque problem that you can't even make up.
So what happened? So the Department of Justice fessed up to the Sixth Circuit and said this ALJ at the Department of Transportation wasn't even properly appointed. So what did
He wasn't even an ALJ.
he wasn't even an ALJ?
Yeah.
Okay.
He was the chief safety officer.
Right.
Okay.
And that's one of the problems that we actually try to get resolved is that he reports to the same person that the chief prosecutor of the agency reports to. So you got the guy who's making the final decision as the judge sitting in the same office as the guy who's prosecuting you. And they both report to the same boss. And if everyone, I shouldn't have to explain any bit why that's problematic. You're supposed to have an independent decision maker make these, adjudications. But we didn't have that.
And years ago, I thought if you wanted a fair hearing, you would go to an ALJ. And I had one company, which is one of the biggest corporations in the world, that told me in 2014, we've had enough. We are getting absolutely used like an ATM machine. The fines increased 25, sometimes 100%. From the first fine to the second to the third, we've got to stand up to this. We've got this case that's completely bogus, absolutely nothing to it at all. So we took it to an ALJ, and I thought, well, they could at least pretend that they're being unbiased. I'd just like to read a little bit from the transcript of the first hearing. I filed a motion to dismiss because the statutory interpretation was wrong, and also because the FAA lawyer on the other side was nowhere to be found. She didn't answer a phone call. She didn't answer the orders the judge filed. So finally, the ALJ held a hearing, and the FAA lawyer didn't show up for that either. And I'm saying you got to dismiss this case. And so what the ALJ says is that, naming the lawyer who has been noticeably absent from the proceeding. She didn't file anything in response to my initial notice requiring the parties to meet and confer. She did not file the response to a notice to show cause, and she didn't appear today. And he says to her boss, "This is a problem. There needs to be somebody from the FAA who is on this case and ready to prosecute this case, because I'm proceeding with this case. I'm moving this case forward either way." Okay, well.
Who needs to prosecute?
Yeah,
Exactly.
that's stunning. So where does it stand then, Sheng? With
So after the DOJ fessed up, they asked the court to vacate the civil penalty and remand back to the agency so that the agency can redo everything they've done to Neil's company. It's already been
over how many year period?
That's already been 7 years at that point.
7 years.
And so just basically start over the prosecution. And we objected to that and said, hey, you should really just dismiss this thing in total. The court wound up vacating the case, giving it back to the agency. And then the agency, the mandate in that case was issued in February or March, I think I want to say. And the agency sat on it for months and months and months. And I remember talking to Neil. I was like, hey, Neil, you're almost out of the clear. The civil penalty against you has been vacated. It's sitting back on the agency desk. But if the agency makes a move against you, tries to re-prosecute you, we have this brief that we already wrote that we will just file immediately on your behalf. And then they just sat on it for a while until finally we told the agency, hey, we will proceed with this a lawsuit against you, asking a court to throw your case out or dismiss your case out, so you can't proceed with it any further. And within a week, the agency sent you a letter, and I think it said it dismissed all counts against you in its entirety, right?
Right.
That must have been a good day.
Mixed emotions, actually. After 8 years, it's part of your life, to be honest with you. And Jerry and I talked so many times, emails and everything going forward. And I didn't realize this case opened up a lot of opportunity to show injustice. And so I kind of started getting on Jerry's side a little bit. I'm like, let's do this. So I almost didn't want it to end. But a lot of emotions, you go through it for 8 years, 7 years. and you hear all along, you think, well, we're moving in the right direction. Maybe this will all be dismissed finally, or the fine will be reduced, or whatever. Something good, hopefully somewhere. And then, Sheng calls me and says, hey, good news. I think Jerry called too. It was vacated, whatever. But the big but was, instead of being dismissed or thrown out, they gave it back to PHMSA where this all started. And I thought, you got to be kidding me. So I said, so I got to start all over. So they literally were saying, okay, we're going to throw it out. But by the way, it goes back to PHMSA. And if PHMSA decides with the right, properly assigned person, whatever the legal jargon is, if that right individual decides to follow through and start the case over, that's what they can do. Now, of course, these gentlemen were both saying, there's no way they're going to do this because you guys know all of this legal stuff that I don't know. And it was like, I was like, oh my God, the luck I've had with this deal, they're definitely going to redo it. We're going to start all over after 7-8 years. We're going to start from square one. They're going to have the right guy sign the document this time, and we're going to have to start all over. And I just thought, I'd say I give up, but he knows I don't give up, and that's why we're all here. But it was really starting to tax me more than I thought it would. So
I was going to ask, did you ever think about just paying the fine just to be done with it? Because I assume some defendants do that. Yeah,
I definitely did. But then the principle of the matter, I think, took over more than the financial part. And so it was, tough deal. Because I know they gave me like a last final, whatever, almost like a 50% off, reduction and all this, whatever. They're like, take this, and I was stewing over it, didn't know what to do. Do I take it? Do I not? I can finally end this thing just by writing a check, whatever. And called, some people, whatever, and discussed where. And really, everybody I was trying to call was busy, to be honest with you. So I kind of had to make the decision on my own. And I thought, you know what? We started up here, we got them here. Now we've got them all the way to here. Now they're offering this. I'm going to take them to here. And so whether it was a good decision or not, I did not accept that and gave them one more counter. And that's when they finally said, you know what, that offer's off the table and you owe us this much money. And I was like, God, I can't believe I did that. Because I had a pretty good deal, and I just thought, oh, they're on a roll. We'll get it one more step, then I'll write the check. And sure enough, last final or whatever, I guess I didn't read the small print, so I was not happy, I'll be honest with you. So I was very upset, to be honest with you. And then he calls, and he's all excited. And I'm kind of like, I'm missing something here, We're probably, now I'm definitely going to have to write a check or whatever. And then he says, no, Neil, I've been waiting years for them to make a mistake or decision like this that allows us for the next chapter to start, which I didn't know anything about, of course. So I was pretty upset, and he's like, here we go.
And you said you called dancing, but say more about that. Like, why was this case so attractive from your perspective?
When you have made arguments about what the standard is in the statute, and you've made arguments about the constitutionality of the ALJ's appointment or whatever, and if you even get a response from the agency to those, and you see how utterly clueless they are about those issues, because the lawyers don't even read their own regulations. Yeah. I mean, they don't understand any of this. They just know that people will write a check to be done with it, like it's a speeding ticket, and even gigantic corporations. The
cost of doing business. That's what the regulators call it.
But it was the Obama administration. That's why I've only been involved with this stuff for the last 12 years or so. The Obama administration are the ones who tried to turn this little bitty agency into the EPA. And it had always been very cooperative with industry, always trying to work out some common understanding of what those 1,200 pages of regulations mean. They always tried to do that, but what they lacked, or what was lacking in getting to the point that we're at is, number one, you have to have a client who's got that kind of courage. That takes a lot to stand up to these guys. I mean, they can figure out some way to put you out of business, if they're smart enough to do that. So it takes a huge amount of courage to do that. And even the biggest corporations are not going to spend what it takes to take this all the way up to the Supreme Court. That's why NCLA was so crucial here. That's what made all the difference in the world. And that's where all the credit goes to NCLA for the backing on that, and for Sheng's terrific work that he's done in the briefs that have been filed in these cases and the other stuff that we have coming down the pike.
Well, I started to interrupt you, but I couldn't interrupt that. But Sheng, why were you so excited when you first heard about the case?
Well, I mean, I think the agency adjudication scheme was just this outrageous, kind of I was about to use a swear word then, but just like a
cluster?
a mess. Yes, a cluster of something. But also just all the merits. You don't actually, because a lot of these times where you have to defend someone against an agency adjudication, the agency adjudication could be really terrible, but you might still, the client might still, this person may have done some sketchy thing or something like that. But on the merits, the case against Neil was just so weak. And I want to let you know the statute that allows the agency to enforce the regulations against a company says they can impose a civil penalty only against a person who knowingly violates a regulation. Knowingly, right? And I just read you those two definitions. Do you think anyone could possibly knowingly, say my thing is a combination versus a composite? That's especially when you consulted the agency. How could you knowingly violate a regulation when you went to the agency and said, which one is it? They tell you, and you act as though the agency told you what was right. So just the fact that
silly rabbit.
That we were, the fact that I think we were just on so far on the right side of the law made this such an attractive case.
See, I would argue that following the agency's advice itself is negligence. That meets the standard.
You should have consulted someone else back in the day. I can't trust these guys.
Well, so what did you think when you heard that this was being dismissed, Sheng? You said, Jerry was saying earlier that, Neil was saying earlier that you guys both thought that would probably happen.
Yeah, we thought so, and it was a little bit, bittersweet. Obviously, we happy for Neil and happy for this all to be over, but we left some stuff on the table. We didn't get a decision on, for example, on the removal protection of the adjudicator. Now he's been properly appointed. Is he still properly accountable? We didn't get an adjudication on whether civil enforcement targets are entitled to a trial by jury, as we believe they should. But we even though this case is dismissed, there are other cases out there, and NCLA is I don't know how much we can talk about it, but there are cases we have in the pipeline that address that address these issues, and against this agency, but also other agencies on these removal protection jury rights cases.
Do you think this was a strategic dismissal on the part of the agency, Jerry?
It's nothing but. That's all it was.
So why do they think why do they think getting rid of Neil's case is going to help them?
Well, where's the next case that's going to challenge them? When are you going to have an opportunity to put this in front of these issues in front of an Article III judge? I think I know the answer to that, but
but they might have thought that it would be hard to come by.
Well, they were even the lawyer who filed this other case that I have in mind was even warned that after the Cochran case was decided, and I was betting it was going to be a 7-2. I never imagined that even Sonia would have been voting in the right way on that case, and it just their policy I know is that Cochran and Axon changed nothing in the way they're going to operate. So the only way that they will be brought to curb on this will be through further litigation. And that's great. I mean, again, that's saying somebody who ordinarily does not do pro bono work, but even on a pro bono basis, I think that's exciting as all get out.
Yeah, absolutely. You're starting to say something else.
Yeah, I think it was strategic too, just because of how it was the last message of that letter to Neil. It wasn't, usually they would say it's dismissed and they couldn't have the same chief safety officer do it, but they could have someone else write the final thing. But they had the acting administrator, and he went out of his way to say, I, as acting administrator, under the duly supervision of Secretary Buttigieg, am dismissing this case on all counts, something like that.
Yeah.
So none of the other decisions that we've ever seen has ever said, under the supervision of the secretary. So based on that, it feels like this kind of decision may have come above the pay grade of whoever actually did the signing. And so that makes us feel like a lot more of a strategic decision to dismiss and avoid, avoid being exposed in litigation that they don't want to face.
Well, I want to come back to potential future actions, at least a little bit before the end. But before we do that, can we maybe jump up to the 30,000 foot level for a second? Because we said at the beginning that there were these protections that were put into place, and in fact, the Bradbury memo was very similar to some of the protections that were put in place across the administrative state by executive order by the Trump administration. It was sort of the Bradbury memo was kind of a prototype or blueprint for a lot of the procedural protections that went in at various agencies. And those were all stripped out, again, by executive order by the Biden administration. So are we going to see these kinds of problems in other agencies? Is there some reason to think this is unique to the Department of Transportation or Secretary Buttigieg?
Not at all. I think I think there's almost like an impossible tension to resolve in every agency adjudication. On one hand, you want for adjudications to be fair, you need the adjudicator to be independent, right, unbiased in some way. But if you have a completely independent adjudicator within an executive agency,
I just gave you an example of one of those independent adjudicators.
But if they're completely independent, then they're they're by definition beyond the control of the president, which then violates Article 2, right? Now, if you then take that adjudicator and say, fine, we'll make them come within the control of the president and have them report directly to the department head or agency head or something like that, and then you run into a different problem. Then you have that problem where you have the adjudicator reporting to the same guy who gives orders to the prosecutor, right? You have the agency head who's giving orders to the adjudicator and orders to the prosecutor, and that presents a due process problem. And I think in agency adjudications, you just really can't disentangle and meet both due process and independence, and as a result, there are always going to be some kind of constitutional defect inherent in agency adjudications. And I love how the Bradbury memo protects due process a lot more, but I don't think even with the Bradbury memo, you have a perfect world where agency adjudications are somehow constitutional.
Yeah, I mean, within the confines of what the statute gives you, I think the Bradbury memo went a long way to provide what protections could be provided. But the problem is a statutory one because the Constitution puts adjudicative power in Article 3 in the judicial branch, and a lot of these statutes try to take that judicial power out of Article 3 and put it in an Article 2 agency, and that's not where it belongs. It belongs in Article 3, at least when there's civil penalties involved, and the kind of thing that we're talking about in this case. So, Jerry, I know your work has mostly been within the Department of Transportation, but what about all these different sub-agencies within the department? Is this unique to PHMSA, or you're seeing these problems at the FAA and elsewhere?
Oh, very much at the FAA, and I have a case that's pending right now that raises all of these issues to the point where I just attached Sheng's work, the briefs that we'd filed in some of these other cases, to our brief, to the FAA decision maker, whoever that could possibly be these days, since there's no FAA administrator. And FAA's response to that was to move to strike Sheng's material out of my brief. The only thing that we got back from the agency decision maker was, no, that motion is denied. We're going to leave, all the attachments.
Going to leave that intact.
There, yeah. So all of those issues in that particular case, every single one of these issues is presented. It's just a spectacular case, and the client has, God bless them, I mean, they have stuck with it. I think primarily because I was saying over lunch that their general counsel actually came to Washington when this case was only 2 years old as opposed to 7 years old. He got on a train, he came to Washington, went to the FAA headquarters, and the lawyer who filed who was in charge of this didn't show up for the meeting that we had scheduled for 90 days. He didn't bother to show up, the investigator didn't show up. He says to the lawyer who was there, tell me what you think we did wrong. And the guy says, I don't know, what will you pay out of this $11,000 fine? And the general counsel's answer was, you won't get $11, much less $11,000, unless you can tell me what this thing says. This makes no sense. And they said, well, okay. So they waited another 2 years. And while the Bradbury memo was still in force, violated the daylights out of it by filing a complaint 3 weeks before the supposed rescission of the Bradbury memo and the regulations, the stuff that was actually codified into the CFR. And so that's where we are.
And what do you think, Sheng, in terms of within DOT? Have you talked to other potential folks? Or is it all PHMSA?
So far PHMSA, although I understand the FAA has its own problems in enforcement. as I mentioned before, we're representing one other company against PHMSA because the same guy who they said was unconstitutionally appointed issued a giant fine against that company. But that's also another PHMSA case.
Well, I wanted to drill down a little bit more on what you were talking about before, Sheng, about one of the major provisions of the Bradbury memo was this idea that if an agency has exculpatory evidence about somebody that they're investigating, that they have to turn it over to the defendant. And as you said, we see this all the time in the criminal context. But we were talking about penalties of thousands of dollars, and I mean, Neil, the numbers that you were saying. How many, did you ever calculate what the total?
Well, yeah, at the time he said
hundreds
maximum fine $475,000 per incident. And on the phone at that time, he said he was up to 9 incidents.
9 incidents. So you're into the millions of dollars.
Let me see which pocket I've got that in.
And so you're talking about millions of dollars, and yet these agencies, when they are in possession of, and just to clarify to our audience, exculpatory evidence means evidence that shows that you are innocent of the charge. Now, you may be completely innocent entirely, or it just may mean that there's some element of the case that that you're innocent of, or it could be this knowledge component that Sheng was talking about, that it might be that you did whatever it is they accused you of, but you didn't do it knowingly, and that's a requirement to show a violation of the regulation. And the agency's position is that they don't have to turn over this evidence to you that you're innocent. That is the Department of Transportation's current position. That is the position of almost every agency in the government, that they can go after you, they can have evidence that you're innocent, and they can keep it to themselves that they have that evidence. I find that it's one of the most shocking components of this case to me. And what we didn't maybe disclose yet is what the exculpatory evidence was here that we had that was really quite telling.
Pretty good. And so in the case that this principle is laid out in Brady v. Maryland, the Supreme Court in that line of cases, the idea why you have this obligation is that when you're the government prosecutor, your job isn't just to win cases. Like, you're not two contract lawyers, on Wall Street just trying to get the bigger payout for your client. Your job as the federal government, as a lawyer representing the government, is to get to the truth and get to justice. And if truth and justice means letting the other guy, see that, hey, we actually have you on camera at a different scene when you're supposedly committing the crime, you're supposed to do that because that serves truth and justice. I don't see how that principle changes when when you move from a criminal penalty to a civil penalty.
To a millions of dollars civil penalty in many cases.
In fact, in criminal cases where you have misdemeanor cases where it is just thousands of dollars of fines, you still have this Brady obligation. But in a $1 million civil penalty, suddenly it's gone. And it just makes no sense to me why this might be the case. And in Neil's particular case, it was particularly egregious in that in the middle of litigation, we said, hey, we think you're withholding exculpatory evidence. Well, we didn't really know, right? Like, it's hard to know, because that's the thing. You don't know what the other guy has that the other guy might give you. And the government wrote in their brief, we don't have any evidence. Don't worry, everything's fine. And then trust us. A few weeks later, I remember it was the middle of July 2021, there was this filing in the case. I was like, well, there's no deadline yet. What's going on? Who's filing this? And it was the government attorney who says, just notice to the court. We actually did another look, and we actually found some evidence that we never disclosed. And we sent this file. I didn't get it, but I think they sent it to Bob, right? They sent it to Bob, who was representing Neil before the agency. And we go to Bob and say, well, what's in there? It was 600 pages of stuff. Just tons and tons of stuff. Some of it is repetitive, but there's a lot of material, including, as I was mentioning before, where the agency went out and it did inspections of companies that were using Neil's products. And they allege that Neil made defective products, right? That if these products enter the stream of commerce, they're unlawful. And all these companies were using Neil's products, and they inspected those companies and said, they're fine, you're fine. You're allowed to put explosives in Neil. Neil's not allowed to make those products, but they're allowed to put explosives in them and ship them across the country.
The agency had looked at his product multiple times and blessed it in these on-site inspections of his customers multiple times, and they didn't turn that evidence over to him as exculpatory evidence when they were coming after him for a severe civil penalty.
That seems to me like a pretty good illustration of why you need this duty on civil enforcement attorneys as well as criminal enforcement attorneys.
Was there also an amended? I seem to remember there was an amended. An amended report
the
as well.
inspector redated, changed the date of a report, and I forget exactly what he did, but he made it seem like basically because we looked at the handwriting, you were like, this is actually the same thing. He just changed the date. This is literally the same report, and we don't know why he changed the date, but he did. And changing that date actually had a legal effect because there's a 5-year statute of limitation. And by making it 6 months, by making the inspection seem like it occurred 6 months
more recently
than it did, he was able to basically tack on 6 months onto that statute of limitations, which, that I think raises some serious questions on what happened. And I wouldn't even thought of it, but
and by the way, that's exculpatory too. If you're statute of limitations information, very exculpatory.
That's right.
But you were I didn't mean to cut you
No,
off.
I was just saying it's something I don't think we could have ever found. I don't know how you would ever have found that evidence unless there was that litigation.
If you
going
think that's
on.
frustrating, though, in my FAA cases, the program people put together a report that goes over to the lawyers. There's a section of the report that says, put exculpatory information here. So when they release the report to the other side, you get page after page after page of just black ink. And I have gone to one ALJ and said, I'm entitled to this stuff. It says right here, this is where you put all the exculpatory information. And the other side said, no, none of that was exculpatory.
Yeah.
End of subject.
And what's worse is in agency proceedings, different agencies will have different rules about how if you're litigating, if you're in a proceeding against the agency, about how you get discovery. And the normal civil rules of discovery, of civil procedure, don't apply in agency procedure. So you can't just go around saying, well, I'm going to take depositions of everybody, or I want discovery on this and that, and I want to read all your emails, which you would get in a civil case in federal court. You don't have that option in agency proceedings. So if you don't have a way of getting affirmative discovery of what the agency has, and the agency has no duty to disclose helpful material to you, how are you supposed to win these cases?
Well, maybe that's the point. Yeah.
It won't matter because the ALJ will move this case forward either way.
Nobody.
Yeah. So let me come to each of you with the same question, which is, what are the takeaways from Neil's experience in this case that you would give to somebody else who's facing an agency enforcement action? What are some of the things that they need to think about or that they need to do and sort of just be on point about? Because I can think of a couple, but you guys have been enmeshed in this more than I have.
To the client?
Yeah.
Just have courage. Just have courage and work with people who know what they're doing on this. And if you can make an arrangement where it's not going to cost you 90 times the amount.
Find pro bono counsel if you can.
Find pro bono counsel, go for it, because thank goodness now there is such a thing. And I would have said 5 years ago there was no such thing. And I was so frustrated with this for so many years. And then somebody, I wish I could remember who, somebody said, there's this guy, Philip Hamburger, give him a call. And I went to the alumni directory, found his cell phone number, called him up out of the blue, and he said, go see this guy. And that's where all of this has come from.
Yeah.
And I wouldn't otherwise, other than whoever that anonymous person was who said, call Phil Hamburger, I wouldn't have, probably today I wouldn't even know that there were opportunities like this.
How about you, Neil? What would you say to other business owners about given your experience with the agency?
Yeah, it's just, we don't know that as a small business owner. A guy comes in with a badge and says, this is the way it is. We're going to shut you down if you don't do this, this, this. And they just start asking for everything. And my secretary, who's been with me 36 years, the two of us were like, whatever he asked for, we just gave it to him. Of course, he's over there going, what? So, but we don't.
Way later.
Yeah, but we don't know that, So he's asking for, customer list, all the list of all the customers using our products, all the test report, asking for all this stuff. And we just think, not knowing, small business owner, well, he knows what he's doing. He works for the government. He's a federal agent. He's got a badge. So we naively just thought, hey, this is the way it goes. And it's funny how I wound up here, to be honest with you. It was a long road, but started with Bob Richard, a consultant. And then also a customer of mine in New Jersey, he had told me about a retired federal DOT agent that is a consultant. So he was, I think, out of Alabama. So I called him, and he educated me on some things, which wasn't a good education. I was ready to go to war, actually. I was like, I've been doing this for 23 years, the same way I do it. I'm diligent about it. Many field agents complimented my test report. This guy can't be right. Let's go. I'll stand in front of any judge. Let's do this. Yeah. But then the retired agent was like, well, you're wrong here. You're wrong here. Or a couple of the single combination package and all that. He told me I was wrong. And I remember just dropping in my seat. I was like, that was the big one I had him on for sure. And so it was rough. I was like, family business just got closed. Yeah. So, but getting a little emotional here because it was a very, very tough thing for me. Because, my dad started the company in like 1969, and then here I am years later running it into the ground. Nice job. So it was a very emotional time for me. And can't say thank you enough to everybody here because.
Well, stories like this are why we do what we do. I mean, we know that these things happen, but we also know that they happen to real people. And so we lose sight of that sometimes. It's one of the reasons we do these lunch and law events is we give our supporters and folks a chance to hear from people like you who've gone through the grinder.
Yeah, and I don't know how to educate the small business people to let them know that, we do have rights, so to speak, or more, because I think I just got really lucky. It's not what you know, it's who you know. There's really something to that. The customer that referred me to a lab to have my products tested prior to the federal agent showing up 7 months later after the nightmare started. I went to this lab on a Thursday, and the agent was showing up at our plant that Monday. And these labs usually take 4 to 6 weeks to perform all the testing for DOT. And these guys heard my story and were like, "Oh no, we're going to get it done for you because we don't like them either." I mean, it was a real team effort going on there. I was kind of like, "God, what did I get into here?" But so they got it done quickly. Literally had it emailed to me about 30 minutes before the agent arrived, and I thought that was going to be great bonus points because instead of just relying on my own testing, I went to what he recommended, a third-party independent lab, and spent $4,400 to have the test done. Even though I know our package is fine, we've done the same way for years. But so I did that, and that really helped out. But who would have thought when I went to this independent lab and I'm standing there in front of the owner and I'm telling him the hell I haven't been sleeping for 7 months, all this stuff. And he goes, "You got to talk to this guy." So he walks me back. I only known the guy for 10 minutes. And he walks me back to his office and he speed dials up Bob Richard, the consultant. So Bob's on the phone and he says to me, "So what's going on here?" And he says, "Well, what's the first offense they had? They've allegedly charged you against or whatever." And I said, "No hazmat training." And I said, "We don't have any hazardous materials in our plant. We make plastic bags." Literally. It just so happens they're used for hazardous materials. And I'd never heard of right to know. So I'm saying point blank to him in his office in Atlanta, the DOT guy, I'm like, "We don't have any hazardous materials. What am I supposed to train my employees on when there's nothing hazardous?" So unbeknownst to me, right to know. So I've got to shut my whole plant down and spend half a day educating all my employees that, this plastic bag you're making, somewhere in its illustrious life, it may be introduced to a hazardous material. Okay? So I'm like, is that what this is really all about? I just was like, this is unbelievable. And so Bob Richard gets on the phone and says, "What's the first offense?" I said, no hazmat training for my employees. And everybody knew right away, it's right to know except me. And so I was like, okay. And he says, "Well, what do you say the fine was?" I said, it starts at $475,000. And Bob goes, "Neil, the last 3 years, the largest fine for no hazmat training was $2,500. He goes, "Can you afford $2,500? I said, "Yes." He goes, "Get some sleep." And that's how this all started, to be honest with you. So, and from there, but your original question though, how do you educate the small business owner that these opportunities are out there?
To stand up for their rights.
Yeah. It's, I guess I'll just give all my customers Sheng's business card and say,
that's a start. That's a good start.
Don't believe everything you hear from these guys that come in waving badges at you, because I had no idea that this has been an education for sure.
Sure.
But I'm extremely grateful for everything everybody does here. So
one of the inspectors actually had his badge embroidered on his polo shirt.
That's not an agency issue. Issued item. Wow. Sheng, how about you? Takeaways for?
Well, yeah. So this is actually my first case at NCLA when I joined about 2 years ago. And when I joined, I obviously have certain ideological beliefs about the administrative state, but they're very academic. They just
Well, you've been at the Department of Labor,
yeah,
so you've seen one
but
agency.
from the other side. But
Yeah.
I haven't really dealt with seen what happens to people who are subject to these enforcement actions in the kind of the labyrinthine nonsense they have to go through. And I was at Department of Labor, I was actually mostly writing regulations, so I was still even a little higher up, not in the weeds. But
You don't know how much mischief you were making. When
exactly, yeah. So just seeing the things that the inspectors and the agency adjudicators were actually doing on a case-by-case basis was just something I maybe may have kind of understood at a high level, but just actually seeing it was something else, and was eye-opening experience.
Yeah, absolutely. Well, before we go to the audience for their questions, which we'll do here in a few minutes, I thought maybe we could talk about, without getting into too many specifics,
Sure.
what's next? What other cases are in the pipeline that might, or what are some of the other issues that folks might be on the lookout for? And one of the reasons I ask this is, whoever's out there listening, they may not have the exact same issue as Neil does, but they might have the same issue as sort of some of the other cases that are coming along.
So the guy that Neil, we won't name names, but the guy that Neil talked to, the owner of that company that helped him out, he's been subject to an enforcement action now. So this has actually worked out. We're kind of keeping in close group of friends here. And that issue has to do with these ticky-tacky little alleged errors in reports that his company submitted to DOT. They do testing too. And just to give you a flavor of some of them, one count involves him in a 2019 report, I guess doing a drop test of one of these packages where you drop it from a height at a certain height, doing it wrong. What he did, he submitted it in January 2019. A week later, a DOT person said, hey, could you redo that test? He redid it, the thing passed, resubmitted the report, everything was fine. 4 years after that, an inspector comes along and tries to fine him for making a mistake in that first test, even though he already corrected the mistake upon being requested. So it's like little things like that. And so we're going to represent this company in a new lawsuit, challenging these not just the merits of the outrageous kind of unlawfulness of the alleged violations, but the whole adjudication scheme, because the agency still, aside from reappointing that one guy who is unconstitutionally appointed, their scheme really hasn't changed. And so I think the same sort of arguments that we mustered in your case, Polyweave, will have equal force here.
And maybe I'll just say, for the benefit of anybody out there who may be looking for services from the New Civil Liberties Alliance, that's what we look for in cases, is not where we can just help one person on the substance of the particular conflict that they have with the agency, but where there's a real procedural problem with how these things are being conducted across multiple cases. And that's one of the things that got our interest about Neil's case, is it gave us an opportunity to really dig in and say, look, there's a problem across the different adjudications that's taking place here that needs to be corrected. And that would be the same in another case that we took on, would just be to have that opportunity to really help more than one person at a time. If we were just helping one person at a time, we could do pro bono work, but it wouldn't necessarily be public interest. And the point of public interest law is to help as many people as we can with the cases that we take on. And so that's an important consideration for us as we do the work that we do. With that, maybe I'll go ahead and open it up to questions from the audience. I see one right over here. Rich?
What lessons you think the Department of Transportation has learned. In particular, it would seem to me that one obvious thing for them to do would be to change their regulations to either make 12 months or 24 months the standard time for inspections, or at least to more clearly spell out the difference between the two types of packaging. Have they made any changes of that sort, or do you hear that they might be anticipating doing that?
Not at all, but what we did hear was they did try to lobby Congress to change that enforcement statute to get rid of the knowingly requirement. So that's something they learned.
To make it strict liability.
To make it strict liability, so they don't have to prove that scienter requirement. My understanding is that Congress didn't take them up on that.
At least not yet.
Okay.
No, not yet.
Yeah. Kara?
We've hit exculpatory evidence issues before a federal judge in an agency enforcement action. And, it's really persuasive to say, that's great that you think that this isn't exculpatory, let's go take it to the judge. But I don't doubt for a second that this is repeated across agencies. It's not just a DOT problem. I mean, is there a fix that to the extent that agency adjudications will continue to happen until NCLA is very successful at unwinding that problem, to make sure that there is some leveling of the playing field, that if there's 600 documents that say, you might not have done this, what is the fix? Is it lobbying the agencies? Is it asking for it affirmatively? Is it a congressional solution?
Well, I'll give you my wish list, and then maybe these guys can give more realistic answers, at least in terms of the short term. But I don't see any reason why the Supreme Court of the United States, in the appropriate case, couldn't say that the Brady principle applies to adjudications in front of agencies when there are fines of this magnitude. I mean, it just seems to me that that is something that would be within the purview of the court to decide as a constitutional matter, that if the Brady rights exist and have constitutional dimension to them, that doesn't go away just because you're in this sort of Article 2 proceeding instead of an Article 3 proceeding. I don't know if there are better ways of handling exculpatory evidence in the short run, or if you think anything else is going to happen.
No, I think that's right. I really don't see the difference between criminal penalty and civil penalty in this context. And at least Justice Gorsuch has said so in an immigration context as well. Or it was an immigration criminal, I forget it was, because it was immigration civil, that's right. But yeah, he has said so as well. And in the criminal context, what you get is you throw out the conviction, which, it seems a little harsh against the government, but that's the...
If they fail to turn over the exculpatory evidence.
Yeah, right.
Not just because they have some.
Right, the violation of the Brady principles, you can throw out, up to throwing out the conviction for. And what that does, it creates the proper incentives for the prosecuting officers to do their job and to look for exculpatory evidence and turn it over expediently when they do find it. And if that principle were applied in the agency context, I don't, it will send the same sort of signal and provide the same sort of incentives.
I would just hope for technology that allow me to unredact those FAA reports.
I thought my answer was magical.
If I could make everything disappear except the words that were there, I'd be very happy.
Yeah. Well, Sheng, remind me, I thought that there was something in the government's brief when they explained that they didn't need the Bradbury memo anymore because they were going to follow principles
That's
like
right.
that anyway.
So
Did they say that?
In the first case we filed, when they rescinded the Bradbury, they were codified in regulations. So they rescinded the regulations, and one of the government's arguments is, don't worry, we didn't need regulations. We still have internal policies that we will follow and that will provide due process safeguards, including this and that.
Even though they weren't before, which is why the regulations were passed in the first place.
So then maybe they're right. Actually, we weren't following before, and we're not going to follow them now. So nothing has changed. Our rescission of the regulations doesn't do anything because we weren't following them in the first place. Maybe that's the point. But it turns out that now that because after the regulations were rescinded, the memo itself was still on the agency's website for a number of years. And the agency position was like, well, we're still following that, so what are you worried about?
And then didn't you tell them that it was still on the website?
Yes, I spoke to John Putnam, who's the DOT general counsel, and I said, why is the Bradbury memo still up on your website? And he said, no, it isn't. And I said, well, I talked to him on a Friday afternoon. When you get back to Washington, maybe you should check. And he got back and said, that's not true. This Cox guy is lying to me, right? And they said, well, no, we decided that nobody else needed to know what our internal procedures were. So why would we put it up on the website? His replacement memorandum, why would they put the replacement up if nobody needed to know what their policies were?
So that happened in April 2023.
Okay.
Putnam had issued a different memo that rescinded the Brady memo, but it was never put on the website.
So no one knew about it?
No one knew about it. There was a secret enforcement procedures, really.
That day it was put on the website.
Yes, on that day in April. But Putnam's memo is dated like in 2022 sometime, right? Like September 2022. So what is that? That's about 6 months where they had a secret enforcement procedure that just wasn't that, if you were subject to enforcement proceeding and you go on the DOT website, and I don't know if a lot of people do this, but they say, oh, I get that protection and that protection, great, I'm feeling good about myself. But when in fact there was a secret procedure going on where you didn't get any of that.
Well, and 2 weeks after that,
That's a great point,
I was
that it was-
trying a case in front of an ALJ, and I said, you have to follow these requirements.
They're on your website.
And the ALJ said, that got rescinded. And I said, and replaced. And I said, replaced by what? And his answer was, well, that's for me to know and you to find out. Okay.
That's not troubling at all. I mean, wow. Okay. Well, if you didn't think that this was the sexiest case that we have, maybe this conversation has changed your view, because I just find this appalling. I thought I saw another question in the back. Yes, great.
In your view, is there any role in the future for this agency? I don't really want to call them adjudication, but quasi-adjudication, perhaps in a form where, as in, when the procedures oftentimes, especially in high-profile cases where you're about to be charged with a criminal offense, you have an opportunity to go talk to AUSA or perhaps even the U.S. attorney to present your case, and they do this sort of quasi-adjudication internally to decide whether or not they're going to bring the case. And I can imagine for some companies, it might be valuable to be able to talk to the agency, perhaps before this quasi-neutral adjudicator saying, you don't have a case to bring, don't take me to federal court. But the final imposition of sanctions would be in a federal court. Would that type of system be A, constitutional, and B, actually useful?
Well, that's exactly what I was mentioning earlier, because the FAA procedures allow you to have an informal conference with the attorney who's charging you with it, and
The one that didn't show up?
violation, and he didn't show up. And like I said, there was an attorney there who hosted, and he didn't bring the regulations into the room. We had a lovely view of the Capitol from FAA headquarters, but the general counsel was like, I tried to tell him how unfair and absurd all of this was, and he didn't believe me, and that's why he spent an entire day getting on the train and coming down from Philadelphia and hearing this for himself. And the only thing that the other lawyer had to say was, how much will you pay? And the answer was not even $11.
Yeah, I think, Greg, I think that would work okay if and only if whatever factual findings that motivated the agency's final decision to eventually go forward against the enforcement target gets no deference when the case goes to court. Because right now what happens is the agency gets to be kind of play a fake judge within their in-house tribunals, and they make all kinds of factual determinations. And sure, after the final decision against you, you can go to federal court. The federal appellate court that you petition has to defer almost entirely to the agency's factual findings, and you can't challenge that. And that's, I think, a real big problem, and also one of the reasons why we're making the argument that you need a right to a trial by jury on those factual determinations, whether in the agency or a federal court.
Russ?
I think the Brady obligation is just a tiny sliver of that. And I don't think we should be conceding that there is a distinction, that there is a semantic distinction, because the statutes call it a civil penalty. But if they're asking for $1 million penalty against a private company,
To shut down a family business that's been in business since 1969, did you say? Yeah.
that's a criminal case. That's a criminal case, and it's not only a Brady problem, but they should have to prove it by proof beyond reasonable doubt. The Sixth Amendment should apply. There should be all sorts of double jeopardy should apply and all those things. And I don't know. I think we should be looking for an opportunity to convince courts not just that Brady applies, but that these are criminal cases and
Well, the
all
entire-
the things that flow from that.
The entire Bill of Rights should apply. I mean, the idea that there's no right against self-incrimination in these administrative proceedings is bizarre
It's
to me
another
as
one.
well.
Yep.
There's
That's a front that I think we need to open up.
Yeah. Do you have any reactions to that?
Yeah, I haven't thought about the whole, right, but I don't see, just sitting here, I don't see why that wouldn't be the case.
It must have felt like you were
Helpless.
in a criminal proceeding. I mean,
Yeah, it was.
the distinction to you was probably not very obvious.
No, and the other thing too, and I don't know if they do this on purpose, but the agent would always email me every Friday afternoon. Just destroy my weekend. I mean, he did that for 7 months. And I mean, there was thousands of emails, and I was sending them all to Bob Richard, and he couldn't believe it. And he said he had a friend, I think, in the agency at the time, and he goes, "This has to stop. This guy is just killing you." So every Friday afternoon, I get another great email that would just tear me up inside. So
What kind of stuff would they say?
We found this, and asking for more information that I knew was going to be detrimental against me, just from what he was saying. And
We know where you live.
it was just getting deeper and deeper every time. It was just like, all right, now I need this, whatever, it just kept piling and piling. I just was like, oh my God, when's this going to end? So it was, and just every Friday afternoon, that might have been part of the reason I didn't give up. Because once I got over the emotional part of it and got angry, then it was like, you know what, enough's enough. Now the principal takes over. This has got to be wrong. I'm in for it for the long run. Let's go. But, it was just the Friday afternoon thing. If there's anything I would change, it'd be make them to do it on Monday. Give me till Friday to fix the problems. At least feel good about it. Maybe enjoy the weekend with my family or something. Imagine that.
Right.
Instead, I'm digging through records and in a funk for the whole weekend for 7 months.
Well, one of the things that jumps out at me about these cases is the extent to which the agency is willing to go to the mat for really, like, even if you had done what they had said are really minor violations, they're willing to destroy businesses, destroy lives over, things that I think, and this goes back to Greg's question, if you had to take that case in front of a federal judge would say, I'm sorry, what are you wasting my time with in some of these, instances, or would say, your chances of winning on this are remote. Do you want to rethink, what you're, how you're doing this? I mean, district judges have a lot of power to settle matters that are in front of them. And I think a lot of these agencies wouldn't even take these cases if they had to be in front of a federal judge instead of in front of an ALJ who says, well, that's for me to know and you to find out. I mean, that's just absurd. Do we have one more question? Sure. This will be the last question.
And so this is based on what you just said about, the Friday emails. If you could estimate how much of the time of you and your secretary and your personnel was dedicated to this, which means it was removed from growing your business, innovating, all of that, what would you estimate that sort of cost has been on you and your business for the past 7 or 8 years?
Yeah, that's quite a question. I did most of it myself. I didn't want to burden her, to be honest with you. We tried to keep the business running, shall we say. But then meanwhile, probably at least 50% of my time was always dedicated to 24/7, just ridiculous. Just, digging, making calls, talking to people as it went on. Talked to Jerry a lot, whatever. And I didn't realize that I didn't have to give him everything he was asking for. I didn't know that. So, Jerry was kind of like, wish we would have spoke sooner, because you wouldn't have probably had to do half the work you did. And whether it was, detrimental to my case or whatever, I'm not sure, whatever. I just was honestly, in good honesty, whatever, giving him everything he asked for. And but yeah, a lot of time for sure. Mainly me though, my secretary, she's a sweet lady, whatever, been with me 36 years. So I don't think she even looked at me and said, I don't even know how you're doing this. She's like, because with everything else that I do, whatever, with a small business owner, and when I say small, we're talking 9 employees. So, the impact on a 9-employee business was very large. So, it was, I can't even put into words how much time I put into it.
And I had one client who was so determined that on such short notice they needed to get a packaging product tested, and the guy put the packaging product in his truck and drove from Lincoln, Nebraska to Illinois, leaving at 6 o'clock of an evening so he could be back the next noon in order to try to satisfy this inspector with his embroidered badge.
And we see this across our cases. It's not just the Department of Transportation, whether it's Michelle Cochran against the SEC, or it's Crystal Maroney against the CFPB, or it's Neil Werthmann against PHMSA. We see these individuals whose lives and livelihoods are being destroyed, and 50% of your time over a multi-year period, the process is the punishment at a lot of these agencies. And that's something that we need to drive home to the federal judges, and something we need to drive home to Congress so that they recognize what they're doing to people who are really being forced to. It's not that the regulation might make sense in some abstract way, but not the way that it's being enforced, not the way that it's being applied, and that problem needs to be resolved and addressed. And one of the ways to do it is to stop having these in-house adjudications, and that's something NCLA cares about a lot, and we wanted to share with you today. So on behalf of the New Civil Liberties Alliance and our esteemed panel, thank you all for attending. DOT backs down after NCLA sues over unfair in-house tribunals. Would you please join me in thanking our guests?